So hopefully I have enough time. Let me just say for the record, I have never understood anybody I've worked with in any capacity to lack the mental capacity to make informed judgments about what they're doing and to be held accountable. And I also understand that legally there's a difference between mental anguish and mental illness. So, with that said, I just want to read three excerpts from something else I did the same day as the other one. It had to do with, I'm just going to read it as it's written. There was something that I was exposed to today that I have not encountered before called cross collateralization. And the understanding I have is that this means that there is an understanding that there is a specific kind of basis upon which an arrangement is made at. And in the arrangement, did that basis then requires a form of performance of a specific kind of promise. But if there is not fulfillment of the specific promise that was uh, in effect provided as part of that which was the specific basis of the agreement, then the default on the fulfillment of that promise allows for other terms to then be made available as part of what is then adjudged to be the results of the default. It means that if you default, then collection for the default can be made not only based upon what the specific basis of the agreement was, but also upon having access to other things that were potentially in a course of providing for that which formed the basis of that agreement. Now, my understanding is you have to acknowledge that up front. That is potentially a condition of the agreement in which you're engaging, that it's not appropriate or legal to ex post facto say that you have access to that option. But let's continue. That he did not specifically identify or articulate to me, and when I did not perform in some sort of capacity, he identified it as a default or a failure to fulfill a promise, and then understood he was entitled to access other things that were not within the specific purview of what was identified by providing those writing samples, i.e., that he saw, for instance, those writing samples as not being so much a demonstration of technique or a specific skill set that then could be analyzed in accordance with determining whether or not I could fulfill the specifications of the specific job, but rather to be a form of inventory on a kind of human capital that he could use as collateral in advancing political objectives associated with the second part of the recommendation, which had to do with a specific strategy about restitution, not only for him, but for others who were impacted by what had happened to him. And there's another excerpt. The thing is, in a course of action of these things, one of the things this is under the instance, there is a legitimate cause to say that oppressive bargaining can be declared, and the effort to engage oppressive bargaining, which can also be a demonstration of the unconscionability and the procedural unconscionability of the engagement of the contract, and was done in an unconscionable way insofar as there was not understood to be that what was being committed to was an effort to then render inaccessible other people for exploitation without their consent in pursuit of aims associated with my agreement to provide certain services in the course of providing it in the course of engaging this contract relation with him. And then the substantive unconscionability is the fact that since then there were efforts to compel me to involve myself in performance of actions that were unconscionable in order to be able to get access to the means by which to fulfill other promises that could potentially be identified as having been made in connection with the agreement to provide the services. I did up to and including provide the outline of the strategic recommendations without any understanding that I was promising or committing to performing any specific role in that strategy myself, or that anybody I personally had been involved with was being obligated to be a participant in the implementation of the strategy. And so the fact that there would be any justification for leaning on me or using me and characterizing somehow that I had defaulted as a means by which to lean on other people in order to effectuate elements of that strategy on someone else's behalf without their informed consent and or without even being apprised of the fact that this contract had been engaged, and by virtue of the engagement of this contract, other people had been implicitly or explicitly obligated into performance of the contract by virtue of being used as collateral in consideration of whatever it was he did with it in a collateral manner without informing me that this was his intent, then that is potentially arguable under an abuse of the dominant party position, that he had a dominant position in terms of having access to certain kinds of resources, up to and including not only a means by which to effectuate certain processes, but also having access to understanding of the potential implications implicit in the contract. He did not make explicit, and insofar as that's the case, then in his dominant position, he has to take responsibility for his understanding of my ignorance or lack of understanding of his intent. And I believe there was actually a demonstration of my ignorance and lack of understanding on two occasions when I specifically said that I had some concerns about something I had borne witness to and I needed actual official legal representation. And second, when I gave him access to information, when I said that I had information that may apply to what he had told me he was dealing with, that he had not been made explicit and had not identified explicitly within the context of our contract relation. Insofar as I had awareness that I had access to information that could have a material impact on things he was dealing with outside of our specific contract relationship, I understood I had a responsibility to inform him that I had cognizance of those factors. And I did that, and he told me he did not understand what the implications were. He did not know what I was talking about. And so the question becomes, did he actually intentionally engage in this action when I revealed to him I had access to that information in order to try to compel some other kind of performance under fraudulent pretenses, in order to then attempt to establish something that he could misabuse to justify having access to other forms of collateral. These had not been understood to have been made available at the onset. Other consideration is into the next consideration has to do with the distinction in terms of the relationship of consideration and kickbacks. Now, I have not read any case information on any legal analysis that discusses the relationship between consideration when it comes to contracts and the legal identification of a kickback. But based upon what I've been able to research and acquire and information about past efforts to make determinations and discuss precedents relating to consideration and the kinds of consideration and the demonstration of assent, which necessitates a contemplation of the role of consideration, then the question of the distinction in terms of consideration and what qualifies legally as determination of consideration, and then the kickback, insofar as there is a sort of interplay between parties in the process of consideration and performance. So what I was reflecting on here was an understanding that there is a consideration of a dominant position when it comes to contract terms, and that insofar as there was any understanding of the availability of processes that could be used in some form of cross-collateralization considerations that had never been made available to me for consideration, had never been disclosed to me as being a potential intent, my understanding is that what was provided was merely a demonstration of my capacity to fulfill a specific assignment, and that the strategy that was presented was something that was meant for his consideration that he could use, but not that the strategy was a promise to compel performance by other people I knew, or to have myself compelled to performance in according with any element of that strategy, including on his behalf, but especially including in a manner that intentionally dispossessed and mischaracterized me as part of the strategy, which itself would have been a misrepresentation of the intent of the strategy itself. Additionally, the consideration of the actual terms and what is explicit as well as implicit also makes a determination about what's allowed to be considered performance. And if, in the course of performing what is already explicitly agreed to, it is made aware that there are potential conflicts of interest or things that might have a material impact on his capacity to fulfill terms of the contract on his end, and I bring that to his awareness, and he says he does not know what I'm talking about and they're not relevant, he does not have a right later on to say that that then becomes an element of promise in that contract that he can obligate me to, or that he can lean on me in order to get access to any sort of collateral that might be available through my human capital inventory. Period. When I asked him for an attorney and he denied it, that was one thing. But there were substantive matters related to the reason why I asked him for assistance with an attorney that made a material difference in the rest of our working relationship. So the understanding here is that insofar as there's a consideration right now going on about how I was supposed to be allowed to merely be used as some sort of proxy for other people to try to make claims through me on their behalf, while the actual substantive literal charges of my case have been completely denied. There was never any contract with anybody to be their errand girl.